greenhouse gas emissions which emanate from activities in all states. Third, certain aspects and principles of environmental law, including climate change law, do not translate to international human rights law. One example is the transboundary or extraterritorial application of some environmental principles, which does not broadly apply to human rights. As a general rule, states must respect, protect, and promote the rights of rights holders who are within their territory and subject to their jurisdiction. Canada has consistently maintained that the jurisdictional competence of a state is primarily territorial and that it is only under very specific exceptions that states may incur extraterritorial obligations under international human rights law. The exception is peremptory norms of customary international law, jus cogens, such as the prohibition against torture, which have no territorial limitation. Canada has, however, not accepted that environmental principles have risen to the status of jus cogens norms. Furthermore, while the notion of CBDR has arisen in the regime for climate change, this does not apply in the specific context of human rights, because human rights are universal, inalienable, and indivisible. Fourth, Canada reiterates that it is supportive of the international momentum to highlight the connection between a healthy environment, climate change, and the enjoyment of human rights. In that light, Canada supported UN General Assembly Resolution 76/300 of 2022, entitled "The Human Right to a Clean, Healthy, and Sustainable Environment." Canada notes, however, that there is currently no common or internationally agreed upon understanding of the content and scope of a right to a clean, healthy, and sustainable environment. Canada looks forward to exchanging information with others to support due consideration of what such a right may comprise and what it may entail within the international human rights framework. It is Canada's firm belief that these considerations do not in any way affect the undeniable obligations that states have to uphold their international human rights law obligations, including when taking action to address climate change, as stated in the preamble of the Paris Agreement. This concludes the 5 points Canada wishes to make for the Court's consideration with regard to the first question. The second question that the Court is asked to examine relates to the legal consequences under the legal obligations of states with respect to climate change, which I just discussed today. As I noted earlier, it is Canada's belief that, as of today, the legal obligations of states with respect to climate change are contained within the Convention and the Paris Agreement. If a state were to fail to fulfill some of its obligations under the core instruments of the climate change regime, parties to the Paris Agreement have agreed to a non-punitive and non-adversarial compliance mechanism through the Implementation and Compliance Committee. The cooperative and facilitative nature of the committee illustrates that to remedy an alleged failure to fulfill an obligation, states parties can resort to the committee, which will look into the alleged failure in collaboration with the state party in question and will determine the appropriate course of action to follow. That said, the Court also sets out the process for the resolution of a dispute between any two or more parties concerning the interpretation or application of the Convention. While parties are to seek first settlement through negotiation or other peaceful means, states parties have the option to accept the jurisdiction of this Court as a means of settlement. Where two or more states parties have accepted the Court's jurisdiction and the Court is asked to consider the legal consequences of a failure to comply with the obligations under the Convention or the Paris Agreement. This would involve the consideration of state responsibility for an international wrongful act. Under the ILC's article on the responsibility of states for international wrongful acts, which largely reflect customary international law, Article 1 states that, and I quote, "Every international wrongful act of a state entails the international responsibility of that state," end of quote. Therefore, for there to be responsibility, there must be an internationally wrongful act. Article 2 of the Articles, Article 2 of the Articles clarifies the elements of a wrongful act, namely that it needs to be an action or an omission, that it is attributable to the state under international law, and 3, that it constitutes a breach of an international obligation of the state. Article 12 of the Articles further specifies that there is a breach of an international obligation when an act of that state is not in conformity with that obligation, regardless of its origin or character. However, Article 13 adds that there cannot be a breach of an international obligation unless the state is bound by the obligation in question at the time the act occurs. As there does not yet exist a norm protecting against the effect of climate change that carries sufficient practice and opinio juris to be considered a part of customary international law, the earliest international obligations that directly arise in the context of climate change are those found in the Convention and the Paris Agreement. Under the principle of state responsibility, a state cannot be liable for something that was not a violation of international law at the time of the action. Consequently, any action that a state took prior to becoming a party to the Convention or the Paris Agreement could not be counted against it as a breach of international law in the context of climate change. Additionally, and as explained by Australia in its oral submissions presented yesterday, a specific causal nexus is necessary to establish attribution under the rules of state responsibility. Climate change is a global challenge for which states have established over many years of negotiation a climate change process through the Convention and the Paris Agreement. Processes under these treaties involve the whole of the international community. This is the only viable route to effectively address the climate change crisis. Much more will be done over the coming years. The ambitions of states must be raised and global actions accelerated. However, the discussions at the governing bodies of the Convention and Paris Agreement are having an impact and progress is made. While recognizing that states have obligations that relate to the factors driving climate change under other treaties, Canada reiterates that these treaties need to be interpreted in a way that is consistent with the international legal obligations carefully negotiated through the climate change regime. Canada remains firmly committed to the UN climate change process through the Convention and the Paris Agreement. Their nearly universal acceptance is testament to their global importance. They are the world's best hope for combating the climate change crisis. Mr. President, Madam Vice President, distinguished members of the Court, this concludes my submission. I thank you for the opportunity to present Canada's views on this matter.
I thank the President of Canada for his presentation. I now invite the delegation of Chile to address the Court, and I give the floor to Her Excellency Ximena Fuentes Torrijos.
Mr. President, members of the Court, it is an honor to appear before you on behalf of the Republic of Chile in these advisory proceedings. The Court has been asked to address two legal questions of the utmost importance that deal with the pressing challenges that climate change poses to our planet and life as we know it. The Court has already had a chance to discuss the key scientific findings in the IPCC periodic assessment reports with their authors, and most certainly will also receive country-specific information during the coming days. It is important to underline that no single region on the planet is immune to the negative impacts of the climate crisis. Addressing the climate change crisis requires significant reductions in greenhouse gas emissions. Unfortunately, not only have we been unable to reduce them, but they have reached a record high. The problem is that while some regions are reducing their emissions, they continue to grow in other parts of the world, undermining the efforts to combat climate change and worsening its deleterious effects. Indeed, UNEP's 2024 emissions gap report indicates that greenhouse gas emissions increased by 1.3% compared to 2022 levels, and that their growth in 2023 exceeds the average rate of the previous decade. The request for this advisory opinion arrives then at the right time, precisely when the COP29 failed to agree on a new collective quantified goal on climate finance that properly addresses developing countries' needs. In this presentation, we will develop two key points. First, I will address the interaction of the climate change regime and the general international obligations related to the protection of the environment and human rights. And then, Ms. Valeria Chiappini will address the legal consequences that arise from a breach of these obligations. The first question posed by the General Assembly to this Court focuses on the obligations of states to ensure the protection of the climate system and other parts of the environment. Therefore, the Court will need to determine the relationship between the general obligation not to cause harm to the territory of other states and areas beyond national jurisdiction, on the one side, and the specific obligations established in the climate change treaties on the other. For this purpose, some observations regarding the climate change regime are important. First, the UNFCCC and the Paris Agreement are binding treaties. Second, the objective of the UNFCCC, as expressed in Article 2, is to achieve a particular result: the stabilization of greenhouse gas concentrations in the atmosphere at a level that would prevent dangerous anthropogenic interference with the climate system. Third, in enhancing the implementation of the UNFCCC, the Paris Agreement, as it explicitly declares, aims to strengthen a global response to the threat of climate change. Fourth, reduction of greenhouse gas emissions in the context of the Paris Agreement is to be attained through ambitious voluntary efforts undertaken by states in the form of nationally determined contributions to the global response to climate change, NDCs. Fifth and last observation, the duty to establish an NDC under the Paris Agreement is a binding legal obligation. But the extent of the specific reductions of greenhouse gas emissions is discretionary. In that respect, the determination of the specific contribution is voluntary and country-driven. In this context, considering the binding and non-binding character of the specific obligations contained in the climate change regime, we can ask whether this regime may exclude or apply with preference to the general obligation not to cause harm to the territory of other states or to areas beyond national jurisdiction. Chile would like to underline that the general obligation not to cause harm is a binding obligation established by customary international law that has been recognized as such in the case law of international tribunals, including these courts. Indeed, in the first case heard in these halls, the Corfu Channel case, the court ruled that every state has the obligation not to allow, knowingly, its territory to be used for acts contrary to the rights of other states. The no-harm rule has continued to be recognized in subsequent decisions of this court, such as in the 1996 Nuclear Weapons Advisory Opinion, the 2010 Pulp Mills judgment, the 2015 San Juan River cases, and the 2022 Silala case. With regard to the standard of responsibility, the obligation not to harm the territory of another state or areas beyond national jurisdiction is not a strict liability obligation, but rather a due diligence obligation. And due diligence is not a simple best effort obligation. The Pulp Mills judgment greatly contributed to the understanding of due diligence in the context of environmental protection, explaining that it entails not only the adoption of appropriate rules and measures, but also a certain level of vigilance in their enforcement and the exercise of administrative control applicable to public and private operators. In examining the content of this obligation, some participants in these advisory proceedings have relied heavily on the distinction between obligations of result and obligations of conduct, stating that this distinction, and I quote, informs the scope of the obligations themselves, end of quote. Chile disagrees with this view. An obligation not to cause harm might take the form of an obligation of result or an obligation of due diligence. And in both cases, the scope is clear: to do all that is necessary to prevent causing damage to another state. A different question is whether the state causing harm should be held responsible. The answer will require an assessment of a state conduct on the basis of the legal standards of state responsibility, either the standard of due diligence or of a strict liability. In the first case, state responsibility will only be incurred if the state has acted without the required due diligence, taking into account the risks involved in the particular activity under scrutiny. In the case of the standard of a strict liability, culpa or lack of diligence would be irrelevant for establishing a state responsibility. If harm has been caused by the actions of a state, then that state will have incurred responsibility. Now, Chile shares the view that the obligation to prevent harm to the environment, including the climate system, is a due diligence obligation. States ought to employ the adequate means necessary to prevent damage, taking into account the present knowledge about the cause-effect relationship between greenhouse gas emissions and climate change. Knowledge about the risks posed by greenhouse gas emissions plays a central role in the application of the standard of due diligence. In this context, the climate change regime should not be understood as a special regime that excludes or applies with preference to the general obligation not to cause harm. Rather, the climate change regime aims to strengthen a global response to the threat of climate change, which includes reducing greenhouse gas emissions and promoting adaptation measures to address the effects of climate change. It was never meant to be the yardstick against which to measure states' compliance with their due diligence obligation not to cause damage. As the International Tribunal for the Law of the Sea stated, compliance with the UNFCCC and the Paris Agreement alone does not satisfy the due diligence obligation not to cause harm to the territory of other states or areas beyond national jurisdiction. Moving now to the interaction between climate change regime and the international law of human rights, despite the fact that they are distinct legal regimes, they do overlap in their application to climate-related acts and omissions. It is evident that a state's failures to limit greenhouse gas emissions may breach international human rights law. In addition, compliance with the obligation to set an NDC in the context of the Paris Agreement might not be enough to prevent harm to human rights. In the Klima Senior Innen case, the European Court of Human Rights decided that Switzerland's failure to take actions to mitigate climate change breached the right to private and family life. In establishing whether the state conduct complied with its human rights obligations, the European Court of Human Rights affirmed that simply having an NDC was not enough. Adequate legislative and administrative measures, including a carbon budget or national greenhouse emissions limitations, were necessary. The state not only failed in establishing them, but even in complying with its past greenhouse gas emission reduction targets, leading the court to conclude that the state failed to adopt concrete measures to protect the human rights of the applicants. Lastly, regarding climate change obligations, it is important to note that a state may also violate the human rights of individuals and peoples outside its territory. Indeed, the Human Rights Committee, in its General Comment number 31, clarified that the obligations under the ICCPR are owed to anyone within the power or effective control of that state party, even if not situated within the territory of the state party. However, with regard to extraterritorial harm caused by greenhouse gas emissions, some states have argued that it would not be possible to speak of a human rights violation situation, insofar as the conduct concerned might not fall within the strict jurisdictional clauses of the particular human rights treaty in question. Chile disagrees with that view. Instead, Chile is of the opinion that in a hypothetical situation where a state willfully or knowingly harms the human rights of a person outside its territory, it would still be possible to describe the situation as conceptually constituting a human rights violation. This has been recognized by the German Constitutional Court in the Neubauer et al. Versus Germany case, when it considered that under the German Constitution, it was conceivable that duties of protection arising from fundamental rights could place the German state under an obligation vis-à-vis complainants living outside Germany to take actions against impairments caused by global climate change. Likewise, the Committee on the Rights of the Child, CRC, in its Hiara-Saki et al. Decision, found that the appropriate jurisdictional test was that adopted by the Inter-American Court of Human Rights in its advisory opinion 23/17 on the environment and human rights. In this case, the CRC considered that when transboundary harm occurs, children fall under the jurisdiction of the state on the territory of which the emissions originated. And I quote, "If there is a causal link between the acts and omissions of the state in question and the negative impact on the rights of children located outside its territory, when the state of origin exercises effective control over the sources of the emissions in question," end of quote. Mr. President, with this I conclude the first part of Chile's presentation, and I kindly request that you give the floor to Ms. Chiappini to address question B.
I thank Her Excellency Ximena Fuentes Torrijos. I now give the floor to Mrs. Valeria Chiappini.
Mr. President, members of the Court, it is an honor to appear before this Court on behalf of the Republic of Chile. I will address the legal consequences under the obligations that have been already detailed by Ambassador Fuentes, where states, by their acts and omissions, have caused significant harm to the climate system and other parts of the environment with respect to particularly vulnerable states and present and future generations. In the present advisory proceedings, the Court has not been called to determine the responsibilities of individual states. Instead, it has been asked how the framework of state responsibility applies in abstract in case of harm to the environment due to climate change. Some states have argued during the present proceedings that the climate change framework is a self-contained regime that excludes the application of the general rules on state responsibility. And they have further argued that even if it were applicable, attribution to individual states would not be possible. Chile disagrees with this view. The framework of state responsibility applies to the breach of climate change-related obligations for the following two reasons. First, the climate change regime does not regulate state responsibility and liability for climate harm. And second, attribution can be established on the basis of accepted scientific consensus, which in any case would be a matter for potential contentious proceedings. Regarding the first argument, Chile sustains that the so-called Warsaw Mechanism for Loss and Damage, established under the UNFCCC, does not regulate liability for damages arising from breaches of obligations related to climate change. But it was rather meant to strengthen the capacity of the parties, and in particular that of developing states, to manage climate risk and implement adequate strategies. In fact, the Warsaw Mechanism mainly focuses on collaborative actions such as enhancing knowledge and understanding of risk management, and strengthening dialogue and synergies among relevant stakeholders. It is meant to increase action and support, including finance, technology, and capacity building between state parties. The subsequent adoption of the Paris Agreement only clarified that it was always the parties' understanding that the Warsaw Mechanism was not meant as a mechanism for compensation. Indeed, the inclusion of Article 8 in the Paris Agreement, which deals with loss and damage, and the Warsaw Mechanism explicitly, was highly contentious during the negotiation of the agreement, because developed countries viewed notions of liability and compensation as a red line. For this reason, the negotiating parties reached a compromise solution embodied in paragraph 51 of the COP decision which adopted the Paris Agreement, and clarified that Article 8, and I quote, does not involve or provide a basis for any liability or compensation. The only conclusion to be drawn from this compromise formula is that while actions taken to implement this mechanism do not entail an admission of responsibility, they can never be deemed a waiver of any rights to liability claims, let alone an abrogation of general rules of international law, such as the state responsibility regime. Mr. President, members of the Court, I will now turn to my second argument regarding the question about attribution. Chile notes that the growing field of attribution science has provided newfound understandings on the contribution of anthropogenic climate change to natural disasters. It is very clear that global warming is proportional to the amount of anthropogenic CO2 emissions. Present-day scientific development allows us to determine, with incredible precision, current and historic emissions of individual countries and their corresponding contributions to the global mean surface temperature rise. It is even able to quantify the disparities between the emissions of major emitters and other world regions. Science can further quantify the real impact that failure to adopt necessary measures has on the overarching temperature goals. Indeed, the most recent scientific consensus has emphasized that the current commitments under NDCs are not enough to address the objectives set out in the Paris Agreement. Currently, a 28% reduction in expected emissions for 2030 is needed to keep the global temperature under the 2 degrees Celsius goal, and a 42% reduction is required for the 1.5 degrees Celsius goal. However, the full implementation of current NDCs do not even theoretically address Article 2 objective. Parties to the Paris Agreement have indeed fulfilled their obligation to submit their NDCs, but the sum of their commitments is not designed to meet our collective goal. The biggest concern is that each year that those commitments are not updated to be fully aligned with the objectives of the Paris Agreement, global warming projections will increase, making it harder to close the gap. In this context, courts would be able to consider existing science regarding states' current and historic greenhouse gas emissions and their contributions to global warming, either to examine the adequacy of the commitments with the collective objective, or assess how much climate change contributes to a particular loss and damage, determining legal consequences that are grounded on the scientific attribution evidence therein presented. Some states have also argued in the present proceedings that climate change is a collective responsibility. But when all are guilty, no one is. That is the popular saying. Nevertheless, this court's jurisprudence has shown that it is possible to attribute individual state responsibility in situations of multiple wrongdoers. Indeed, the court made clear in the Armed Activities on the Territory of the Congo reparations judgment that when multiple actors contribute to causing harm, the responsibility for that harm should be divided among them based on the respective contributions. The court has found similarly in the Corfu Channel case and the certain phosphate lands in Nauru case. In fact, the ILC has also recognized that under the law of state responsibility, and I quote, Each state is separately responsible for the conduct attributable to it, and that responsibility is not diminished or reduced by the fact that one or more other states are also responsible for the same act. Lastly, regarding the causal nexus for the purposes of compensation, this Court has acknowledged that lack of sufficient evidence of the exact extent of damage does not always prevent awarding compensation. To account for these exceptional situations, the Court has awarded compensation in the form of a global sum. As the Court explained in the armed activities case, and I quote, "Such an approach may be called for where the evidence leaves no doubt that an internationally wrongful act has caused a substantiated injury, but does not allow a precise evaluation of the extent or scale of such injury." End quote. Mr. President, members of the Court, voluntary efforts to reduce global warming have thus far failed. As put by UNEP in their most recent report, ambition means nothing without action. Mitigation efforts implied by current policies will lead global warming to a maximum of 3.1 degrees Celsius this century, exceeding all tipping points. If this ambition level continues, there is virtually no chance of meeting our collective goals. We are on track to overpass the 1.5 degrees Celsius threshold above pre-industrial levels in less than a decade. Through these proceedings, the Court has the historic opportunity to affirm the applicability of existing international law to the climate crisis, ensuring that the rights of present and future generations are not forsaken. Let us not inherit the regret of inaction, but instead let us choose the courage to act. Mr. President, members of the Court, this concludes Chile's presentation. Thank you for your kind attention.
I thank the representative of Chile for their presentation. I now invite the delegation of China to address the Court, and I give the floor to His Excellency Ma Xinmin.
Mr. President, distinguished members of the Court, good afternoon. It is a great honor and privilege to appear before you on behalf of China. Climate change is an unprecedented global challenge for humanity. As a developing country, China deeply understands the enormous difficulties faced by developing countries, particularly vulnerable small island states, in confronting its impacts. Following China's written statement, my presentation will focus on 6 parts. First, jurisdiction. Second, applicable law. Third, obligations of states. Fourth, legal identification of GG emissions. Fifth, legal consequences. And finally, China's action. Mr. President, I will start with Court's advisory jurisdiction. China affirms its support for the Court exercise of advisory jurisdiction in accordance with international law. We hope the Court will focus on the identification and the clarification of lex lata and refrain from the development and applicable of lex ferenda. China also hopes that the Court will uphold the UN climate change negotiations mechanism as primary channel for global climate governance, promote harmonized and consistent interpretation and application of international law, and prevent fragmentation of international Climate Change Law. Mr. President, I will now turn to applicable laws. In China's view, this adversary opinion engages multiple branches of international law. UNFCCC, together with Kyoto Protocol and the Paris Agreement, constitute a basic legal regime of global climate change, climate governance. It lacks specialists tailor-made to address climate change. Therefore, it should serve as core and primary law guiding the course deliberation. For matters not regulated by the UNFCCC regime, other branches of law, such as UNCLOS, human rights treaties, and relevant rules of general international law, may play a complementary role. However, their application must consistent with the purpose, principles, and the rules of UNFCCC regime. Mr. President, I now turn to the obligations of states under the UNFCCC regime. The UNFCCC and its Kyoto Protocol and the Paris Agreement form a coherent and harmonious framework. The UNFCCC provides foundation, while Kyoto Protocol and the Paris Agreement are implementation agreements that build upon, supplement, and the development foundation. The three should be applied uniformly and interpreted consistently. The right, obligations, and responsibilities of states under the regime must be determined fully and accurately in accordance with ordinary rule of treaty interpretation. I highlight three key points. First, the purpose climate action under the regime require integrated approach that coordinates multiple objectives. They aim not only to address climate change threats, but also to be in the context of, to promote and achieve sustainable development and poverty eradication on the basis of equity. China emphasizes that addressing climate change is a comprehensive and systematic undertaking with broad implications. Limiting climate action solely to the threat of climate change without considering other compelling objectives reflects unduly narrow perspective. Second, principles. Climate action must adhere to the principles of regime, including sustainable development, equity, CBDRC, and cooperation, with a particular focus on safeguarding the right to development for developing countries and their peoples. The principle of sustainable development under the regime affirms that parties have both the right and responsibility to promote sustainable development. Moreover, parties must respect, promote, and consider their respective obligations regarding the right to development, which is both collective and primary. Economic development and poverty eradication are the legitimate priority needs of developing countries. This includes ensuring access to resources, acknowledging their energy consumption must increase. The principle of equity under the regime requires parties to protect the climate system for all present and future generations. In terms of equity of present generation, The regime requires consideration of developing countries' unique challenge and cost related to moving away from fossil fuels and their limited capacity to withstand the negative impacts of climate action. The Paris Agreement underscores the imperative to support developing countries. In the light of above principles, the international community has a clear obligation to ensure that developing countries can enjoy the right to development, including equal access to development opportunities and emission space. In this context, certain states have imposed arbitrary and justified unilateral measures that stifle growth of green industries in developing countries. These measures both undermine the right to development and violate the principle of cooperation to promote supportive and open international economic system. Third, obligations and responsibilities. Under UNFCCC regime, states must adhere to the principle of CBDR when fulfilling their obligations and responsibilities to protect the climate system. CBDRC remains cornerstone of international climate change regime. This principle, embodying equity, is established by UNFCCC and reaffirmed by its Kyoto Protocol and the Paris Agreement. Claims that Paris Agreement abandons this principle are baseless. First, the Paris Agreement as implementation agreement under the Convention inherits and carries forward this principle. The agreement's main provision distinguishes between obligations and responsibilities of developed and developing countries in various areas, including mitigation, adaptation, finance, technology, capability building, and transparency. Second, Paris Agreement further reinforces legal basis for differentiated responsibility through the phrase, in the light of different national circumstances. Third, while mechanism of NDCs applies universally, their scope, ambition, and level reflect CBDRC acknowledging differing capabilities and circumstances of developed and developing countries. The UNFCCC regime imposes CBDR on parties. It includes legally binding obligations, non-legally binding political commitment, moral responsibilities, and other advisory or voluntary actions. Although these provisions differ in their effects or functions, they collectively represent the international community's consensus and constitute a package agreement that parties must implement in its entirety. Mr. President, regarding common obligations and responsibilities of all parties, I underscore common objective and general commitment. First, all parties should collectively pursue common objectives of climate action. Paris Agreement sets out 3 specific goals for strengthening global response to threat of climate change: limiting global warming, addressing adaptation, and aligning financial flows. Regarding the long-term temperature goal, Paris Agreement sets a time framework for global mitigation efforts and recognizes that developing countries require longer time frames for emissions peaking. It is clearly demonstrated that developed and developing countries follow different paths toward carbon neutrality. These goals are collective, applying to parties as a whole rather than individual parties. They constitute shared political commitment, not concrete legal obligations. Importantly, they combine temperature limit, application, adaptation, and finance goals. Rather than focusing solely on one temperature goal, the long-term temperature goal sets a range from 1.5 C to 2 C, rather than a singular 1.5 C target. Secondly, all parties are to collectively undertake and communicate their ambitious climate efforts to achieve the purpose of Paris Agreement. The term R2 indicates direction rather than legal obligation, expressing the parties' general commitment to progressive efforts in various areas. Regarding each party's specific obligation and responsibility, each party shall prepare, communicate, and update progressive and ambitious NDCs, and pursue domestic measures to mitigate and adapt to climate change. The obligation-related NDCs are conducted-based ones, undertaken at international level. However, the scope, form, and ambition of NDCs remain subject to each party's determination. Mr. President, next I will examine differing obligation and responsibility of developed and developing countries. Why distinguish between developed and developing countries? Let me be clear. The distinction is not a gift from developed countries. It is firmly grounded in justice and law. Three factors determine the distinction, that is, historical GG's emission before the UNFCCC adoption, the capacity to tackle climate change, and the national circumstances. In the terms of national circumstances, the following aspects should be taken into account. In particular, development stages, people's basic needs for survival, livelihood, and development. Resources endowment, industrial structures, population size, transference of emission between countries, and cost effectiveness. For developed countries, they bear more and greater obligations and responsibilities. First, the developed countries shall undertake quantified emission reduction and should lead mitigation efforts and adopt economy-wide absolute emission reduction targets. Second, they shall provide developing countries with means of implementation and shall report information regarding such means provided. Also, they will fulfill their commitment to lead in providing and mobilizing climate finance of at least $300 billion annually by 2035. the doubling of adaptation finance by 2025. China submits that developed countries have an obligation to bear their historical responsibility. RPCC reports reveal that historical emissions from developed countries are primary cause of current climate crisis and injustice. The UNFCCC explicitly notes that the largest share, historic and current global emissions of GHGs have originated in developed countries. Moreover, historical responsibility lies at the very heart of the UNFCCC regime. Developed countries should bear great legal obligation and more responsibility based on climate justice, the principle of equity, and the provisions of the regime. The Cancun Agreement reaffirms that developed countries, due to their historic responsibility, must lead efforts to address climate change and its adverse effect. For developing countries, they will make the greatest efforts within the respective capabilities in the context of their sustainable development. Beyond common obligations and responsibilities, they are encouraged to gradually move forward economy-wide emission reduction or limitation targets. Moreover, they may voluntarily provide finance to support other developing countries' mitigation and adaptation efforts. It must be emphasized that developing countries' implementation of commitment depends on developed countries' effective meeting of their obligations regarding means of implementation. Any financial flow between developing countries remain completely voluntary without any legal obligation. Mr. President, I now turn to the legal identification of GHGs emission. Some countries have characterized anthropogenic GHG emission as a pollution of marine environment. Under UNCLOS, China holds a different view on this matter. First, such identification goes against UNCLOS' intent. The Convention does not mention the term such as climate change or greenhouse gases. The Convention preparatory material clearly establishes that state party did not intend to include GHG emissions within the scope of marine pollution. While treaty interpretation may involve, it must respect the state party's original intent. Any attempt at de facto legislation beyond the Convention's intent would contradict the principle of state consent. Second, such identification is not supported by scientific evidence. Determining whether the adverse effect of anthropogenic GHGs constitute marine pollution is fundamentally a scientific question. Such a determination cannot rely solely on legal reasoning. CO2, primary anthropogenic GHG, is not inherently harmful. It is essential for life on Earth and its ecosystem. Determining whether the adverse effect of oceans' absorption of CO2 constitute pollution requires an evidence-based scientific assessment. Last but not least, Such identification fails to account for the unique nature of adverse effect from GG emission. Unlike conventional environmental pollution, the effects from GG emission are global and historical, make it difficult to identify specific sources, establish causation, or attribute responsibility. Accordingly, the legal rules governing environmental pollution do not apply. IOC draft guidelines on the protection of atmosphere define climate change as atmospheric degradation, distinguishing it from atmospheric pollution. Also, no international consensus exists to recognize GG emissions as pollution. China is the view of that. Adverse effect from anthropogenic GG emissions are in a sui generis legal status. The court is respectfully urged to leave this matter to be determined through scientific research and state practice or international lawmaking. Mr. President, I move on to the second question raised in the request. GG emissions do not constitute internationally wrongful act under general international law. The resulting loss and damage cannot be addressed through state responsibility or liability regime. The UNFCCC regime has established a special assistance arrangement for loss and damage and a unique compliance procedure. Mr. President, I now turn my attention to China's actions and contributions. China has firmly implemented its national strategy to actively address climate change. President Xi Jinping has underscored that our climate action stems from our choosing, not external pressure. Guided by Xi Jinping's thought on ecological civilization, China's climate action remains unshakable, regardless of international development. Consider these examples. Since the 1990s, China has lifted 658 million people out of poverty, accounting for 75% of global progress in the poverty reduction. This marks the greatest achievement in human history. China is advancing its dual carbon target comprehensively, with the carbon peaking plans spanning 12 industries and 31 provinces. At the recent COP29, China further pledged to submit its 2035 NDCs, covering the whole economy and all GGs. China leads the global green and low carbon transition, contributing 60% of the world's newly installed renewable energy capacity. Despite no obligation, China has provided and mobilized over 177 billion RMB for fellow developing countries since 2016 through South-South cooperation. Mr. President, action is key to addressing climate change. As a responsible major developing country, China stands firmly as both a committed practitioner and driving force in climate action. We are committed to working with the rest of the world to protect Earth, our shared home. Together, we can build a community with a shared future for humankind. Mr. President, distinguished members of the Court, that concludes China's statement. On behalf of Chinese delegation, thank you for your kind attention. I also thank the registry and the staff for their assistance. Thank you all.
I thank the representative of China for his presentation. Before I invite the next delegation to take the floor, the court will observe a break of 15 minutes. The hearing is suspended.
Oral statement. Thank you very much.
I thank His Excellency Luis Gilberto Murillo Urita. J'appelle à présent à la base.
Let me now call to the podium Her Excellency Diana Carolina Olata Bakaris. You have the floor, Madam.
Monsieur le Président,
Mr. President, Madam Vice President, honourable members of the Court, it's a great honour for me to appear before you on behalf of the Republic of Colombia. The Foreign Minister has just highlighted the determination of our country to fight against climate change through significant national actions. However, as we all know full well, national efforts alone will be and are insufficient because of the global nature of the crisis, which requires a joint and universal response based on international law. The position of Colombia, as concerns many of the issues raised, is described in detail in our written submissions. My oral presentation today will only cover a few key aspects related to the two main questions put to the Court. Let me at this point, at this juncture, mention the first part of my argument, which will look at the international legal obligations applicable to climate change. Climate change obligations are rooted in the regimes established by the United Nations Framework Convention on Climate Change, the Kyoto Protocol and the Paris Agreement, but they also extend far beyond. We therefore invite the Court to consider that a piecemeal approach to international law cannot help us face the current climate crisis. In this context, therefore, Colombia holds that the principle of international environmental law are key to understanding and interpreting the obligations of states in the fight against climate change. Let me mention a few. First, at the heart of international environmental law lies the obligation for states to prevent significant harm to the environment, both within and without their borders. Within the broader context of climate change, this obligation extends to the reduction of greenhouse gas emissions and to safeguarding those ecosystems which are key for the health of the planet. Second, the due diligence principle demands that states take all necessary, reasonable and appropriate measures to prevent damages stemming from activities under their jurisdiction. Given the changing nature of climate science, this principle requires states to assess the risks proactively and to implement mitigation measures. Due diligence is not a static obligation. It changes with the advances of science. Colombia calls on the court to recognize that a lack of due diligence on climate change because of inadequate or lack of actions may lead to irreversible damages. Third, Colombia recalls that the climate crisis cannot be effectively dealt with without international cooperation amongst states. Both the UNFCCC and the Paris Agreement state that international cooperation is required to reach climate goals. The principles of common but differentiated responsibilities and respective capacities provides that though all states share a responsibility to fight against climate change, those with the greatest historical emissions and capabilities should bear a larger share of the burden. These principles should guide our attenuation and mitigation efforts within global climate actions. To fully reach those goals, developing countries, which often house the largest carbon sinks and often have the most significant development challenges, need support in the form of finance, a low-carbon technology transfer, and capacity building indeed. Lastly, Colombia notes that there is a broad convergence in the written submissions on the interpretation and application of the state's obligations under the principle of intergenerational equity. Colombia holds that in the current climate emergency, states should strive to guarantee justice and fairness in the use and conservation of the environment and of natural resources, which requires them to take account of inequalities between generations. Colombia invites the court to consider that intergovernmental equity, as a norm of customary international law, lies at the heart of the climate change-related policies and negotiations.
Mr. President, if the Framework Convention and the Paris Agreement are indispensable to international climate action, they must not be considered in isolation. Colombia feels that these agreements must be interpreted in conjunction with other international legal regimes, inter alia, human rights, and environmental law. And this in order to guarantee that states do comply with all their obligations in international law, whilst at the same time complying with their climate commitments. Colombia, dismisses the argument whereby an approach based on lex specialis would exclude the application of principles of international law or other legal regimes. The obligations flowing from the Framework Convention and the Paris Agreement are complementary to other legal undertakings and neither replace nor exclude them. Mr. President, distinguished members of the Court, the combat against climate change requires nothing less than a whole and consistent approach and application of the various relevant bodies of law. The lack of consistency between legal regimes often results in profound difficulties in harmonizing their application. This fragmentation compromises their effectiveness and exacerbates the contradictions between different obligations. Mr. President, distinguished members of the Court, let's be more precise. Climate change isn't only an environmental question, it's also a serious threat to the fundamental right of individuals. By that I mean the right to life, the right to health, and the right to a healthy environment. The degradation of environment caused by climate change has direct and serious repercussions on the enjoyment of these rights. Now, Colombia, like many other states, is firmly persuaded that the harm caused by climate cannot be excluded from the scope of application of human rights obligations. States have the duty to include human rights considerations into their climate policies and actions. If they don't, not only will they infringe international law, but the most vulnerable populations will not enjoy adequate protection. Those obligations flowing from human rights treaties extend without a doubt to climate harm. Colombia is wholly against the position of states who argued the contrary. A restrictive interpretation can only be a source of additional fragmentation. The jurisprudence of human rights bodies and courts underscores the intrinsic links between environmental protection and human rights. The duty to prevent harm, and the obligation of due diligence apply across the board and aren't limited by specific treaty provisions. They include the duty to protect individuals from foreseeable harm, including that caused by climate change. Furthermore, the extraterritorial nature of climate impact acutely highlights the necessity for states to act beyond their borders when their acts or omissions affect the rights of others. Colombia asserts that the extraterritorial application of human rights is crucial in the context of climate change. The impacts of climate change don't stop at national boundaries, and states must recognize that their actions or lack thereof can have considerable consequences for persons and communities well beyond their own borders. Obligations linked to climate change must be read together with other applicable legal regimes. In interpreting these obligations as a whole, states can't selectively exempt themselves from their international responsibilities. In other words, the breach of obligations linked to the environment, to climate change, is also a breach of human rights. Mr. President, distinguished members of the Court, pursuant to Article 31, paragraph 3.c of the Vienna Convention on the Law of Treaties, treaties must be interpreted jointly with other relevant rules of international law. Now, the principle of systemic integration requires that the UN climate change regime be interpreted in harmony with other applicable legal norms, such as human rights and customary international law. Let me be clear. The Court is not being asked to create new legal obligations, but to clarify existing legal corpus relative to climate change. The opinion of your jurisdiction, of your court, on relations between climate change treaties and other applicable legal norms will contribute to clarifying the obligations of states by bolstering the global legal framework in the fight against climate change. Thus, for example, the Inter-American Court of Human Rights, in its advisory opinion OC 23/2017, recognizing the interconnection between environmental obligations and human rights, showed that such harmonization is possible. A consistent and integrated approach would not only clarify the contours of state obligations with respect to climate change, but would also reinforce the efficiency of international cooperation in the fight against this urgent global challenge. Your advisory opinion will thus play an essential role in reinforcing the consistency of international law to collectively strive against climate change. Mr. President, distinguished members of the Court, let me now move into crucial questions raised by question small b, the request for the advisory opinion. At the heart of this request lies the question of legal consequences for states whose acts or omissions have occasioned important harm to the climate system and to the environment. Your court has a long tradition of clarifying the consequences of internationally wrongful acts, and that includes within the framework of advisory proceedings. Recently, in your advisory opinion on the legal consequences of the policy and practices of Israel in the OPT, including East Jerusalem, 2024, the court reaffirmed the principle whereby wrongful acts entail legal consequences. Inter alia, the cessation of the unlawful conduct, reparation, and, if need be, compensation. Colombia argues respectfully that the court should continue this well-established practice by clarifying the consequences of breaches by states of their climate change obligations, particularly those which bring about serious harm to vulnerable populations and ecosystems. Colombia underlines that many are the international legal obligations currently being breached, and this gives rise to internationally wrongful acts. These obligations aren't limited just to specific regimes of the Framework Convention or the Paris Agreement, but extend to the principles of international law, including the no-harm duty, the obligation to respect human rights, and other bodies of obligations. Let us recall, to start with, that the ILC articles on state responsibility are directly applicable in the context of climate change. Neither the Framework Convention nor the Paris Agreement contain special secondary rules in this regard. Thus, it isn't possible to exclude the principles of the ILC articles just by using a lex specialis approach. Colombia further argues that anthropogenic GHG emissions must be considered a composite wrongful act under international law. The harm caused by climate change isn't the result of isolated incidents, but rather of an accumulation of acts and omissions by states over time. The concept of a composite act or fact, as defined under Article 15 of the ILC articles, applies to a series of acts or omissions which collectively lead to a breach of international obligations. Mr. President, the continuing environmental harm which lies at the heart of the climate crisis has profoundly affected states, in particular their environment and their capability to guarantee human rights, which constitutes serious harm. This conduct is a continuing international breach which persists over time and which comprises both the acts and omissions of those states responsible. Now, some states have argued that the complexity of attributing emissions-related climate change harm renders establishing state responsibility a difficult proposition. However, the instant advisory proceedings do not require the court to rule specifically on questions of attribution. Emphasis should rather be placed on the legal principles applicable to such breaches. Mr. President, distinguished members of the court, let me now to move to the second aspect of international responsibility. The legal consequences of failure to comply with climate change obligations are clear. They comprise of cessation and non-repetition of harmful activities, reparation of harm caused, and, as need be, compensation. The obligation to cease ongoing violations, such as the continued excessive emission of GHGs, is fundamental under international law. If the breaches continue, states have the duty to take all necessary measures to put an end to the harm. So it falls to the court to determine the legal contours of the reparation commensurate with the harm suffered. The complexity and scope of the instant request shouldn't prevent the court from applying the rules of international law to respond to these questions, taking into account the specific circumstances linked to the type of harm caused and the source of the harm itself. The reparation of climate harm should be considered in the light of legal responsibility, recognizing the disproportionate contribution of certain states to global GHG emissions. The principle of restitution should guide the efforts aimed at restoring the environment to its prior state as far as possible. In cases where restitution is just not possible on account of irreversible harm, compensation becomes a form of necessary reparation. As Colombia has indicated, compensation may consist of financial assistance to vulnerable states, or it could take the form of instruments such as debt for climate action swaps, debt for nature swaps, or green bonds. For Colombia, compensation shouldn't be considered as a question of discretionary goodwill, but as an obligation flowing from the continuing breach of international law on account of the continuing commission of internationally wrongful acts resulting from historical and current emissions of greenhouse gases. Mr. President, distinguished members of the Court, Colombia respectfully urges the Court to adopt a systemic approach to the interpretation of international law applicable to the fight against climate change. A piecemeal interpretation of applicable law would compromise global climate action. Colombia feels that the Court is particularly well placed to provide a complete and authoritative clarification of the legal consequences of climate change-related internationally wrongful acts, both for ongoing breaches and potential future ones. This clarification is essential to give the UN and its member states indications on the complete scope of their legal obligations and on the consequences should they breach them. Mr. President, Madam Vice President, distinguished members of the Court, I'd like to thank you for your kind attention, and this brings to an end the oral presentation of the Republic of Colombia. Thank you very much, the representative of Colombia.
Delegation, the Commonwealth of Dominica. to address the court, and I call upon Mr. Levy Peter to take the floor.
Thank you, Mr. President. Mr. President, honourable members of the court, it is a sobering subject upon which I have the honour of making this opening statement to the court on behalf of the government and people of the Commonwealth of Dominica. And I am pleased to be doing so in unison with nations of the global community. To echo the words of our Honourable Prime Minister Roosevelt Skerrit at the 72nd session of the United Nations General Assembly in September of 2017, we in Dominica are on the front line of the war on climate change, a war we did not start and a war in which we are the innocent casualties. Politically, Mr. President, Dominica attained independence from the United Kingdom on the 3rd of November of 1978. Mr. President, that therefore means that exactly 1 month ago today, Dominica celebrated its 46th anniversary of independence. Mr. President, the Commonwealth of Dominica is approximately 750 square kilometres and has a coastline of some 148 kilometres. It is located at the approximate geographic centre of the archipelagic chain of islands in the Caribbean Sea known as the Lesser Antilles. Mr. President, slide 1 is a map of Dominica and indicates its topography and positioning. Our population is approximately 73,000, the majority of whom are of black African descent, and the second largest grouping, Mr. President, are indigenous Kalinagos. Mr. President, topographically, the Commonwealth of Dominica is a mountainous and rugged volcanic island whose terrain is crisscrossed by numerous deep valleys, rivers, streams, waterfalls, sulfur vents, natural hot springs, and is widely covered by dense tropical rainforests. Our tropical rainforests are home to an array of once thriving biodiversity, including flora and fauna, some of which is not found elsewhere in the region, or in some instances, for example, the Cicero parrot, Dominica's national bird, anywhere else in the world. Also, on the threat is the mountain chicken, otherwise known as a crapo. Both of these are listed as critically endangered species, and together with other species, are at increased threat to their survival in consequence of the increasingly extreme climatic events. Mr. President, in keeping with the foregoing, and Dominica's widely accepted status as the nature island of the Caribbean, some say of the world, special protection areas, including 2 large forest reserves and the Mont Tuapito National Park, a UNESCO World Heritage Site, have been created to protect and preserve the environment. Economically, Mr. President, as with many small island developing states, the Commonwealth of Dominica has a relatively small and open economy. The Commonwealth of Dominica is actively and sustainably nurturing its tourism industry and is increasingly promising a small micro manufacturing sector, all while making a significant investment in the development of geothermal energy production. However, Mr. President, the nation's growth and development have been and continue to be significantly put at risk and in several cases stymied by the repeated destructive climate-related crises that we face. Mr. President, in terms of climate change events and impacts on Dominica, it is important to note that Dominica's location at the center of the Lesser Antilles positions it squarely in the bullseye of the Atlantic hurricane belt, directly in the crosshairs of the ferociously intensifying storms These storms form off the coast of West Africa and journey across the Atlantic Ocean to unleash havoc and destruction on Dominica and the wider Caribbean. Mr. President, the second slide indicates the positioning, and Dominica is highlighted by a circle. The human-induced climate change is greatly exacerbating this geographic vulnerability by supercharging the ocean waters, increasingly making Dominica and other small island developing states particularly susceptible to these hydrometeorological hazards, causing the increased frequency and intensity of high-powered hurricanes, tropical storms, floods, drought, storm surges, and sea level rise that we have been experiencing and are projected to continue to experience into the foreseeable future if urgent action is not taken. Dominica has been badly affected by hurricanes, tropical storms, and other climate events, but particularly, Mr. President, by hurricanes and tropical storms. These have impacted Dominica with increased frequency and intensity over the past 60 years, as is demonstrated by the following. Between 1967 and 1978, Dominica experienced just one major storm, namely Hurricane Dorothy, and one recorded significant rainfall event. However, Mr. President, between 1978 and 1989, Dominica experienced 7 hurricanes, one being Hurricane David, which history revealed was one of the most powerful of the last century. In addition to that, there was one tropical storm and one recorded significant rainfall event. Between 1989 and 2018, Dominica experienced 11 hurricanes, 5 tropical storms, and 8 recorded significant rainfall events. It will be noted that that period also saw Dominica visited by the dreadful Hurricane Maria in 2017, about which I shall say a little more shortly. Between 2018 and the current time, Dominica has been affected by 21 hurricanes. Not all have hit Dominica directly, but all of the 21, which are named in the documentation highlighted in the footnote reference, all of the 21 have affected Dominica in some way, some fashion. This, Mr. President, represents an explosion in the number of major climate events adversely affecting Dominica and includes, as I indicated, the monstrous Hurricane Maria, which utterly decimated the island in September of 2017. And Mr. President, a slide is included, it's slide 3, and also another slide, slide 4, which indicates some of the damage, but in no way encapsulates the extent of the damage suffered by Dominica as a result of Hurricane Maria. Mr. President, I shall say a little more about Hurricane Maria, but I think
people have lost their homes and properties and lives to the landslide
video and allow it to play for a short moment, which relates to Tropical Storm Erika in 2015.
People have lost their homes and properties and lives to the landslides and mudslides, and much of the island does not have power at all. Most of the major road networks on the island are impacted. The airport, as I understand, has sustained damage to the tarmac and the buildings, so the airport is closed until further notice. I don't think that the images that you're seeing adequately demonstrate the severity and the widespread nature of this disaster. Deidre Robinson for CBS News, Rosa Dominica.
Mr. President, the consequence of these storms has been immense, causing immense damage and loss. And of course, as a small island state, we are in a cycle of storm damage, and then recovery and reconstruction, and debt incurrence, and that cycle continues. Mr. President, we need the protection of the international legal system and structure, and with that, Mr. President, with your leave, I yield to Ms. Sobers-Joseph, who will conclude the presentation for Dominica. Thank you, Mr. President.
I thank Mr. Levy-Peter, and I now give the floor to Ms. Sobers-Joseph.
Mr. President, Madam Vice President, and all the members of the Court, it is my privilege to appear before you and an honor to do so on behalf of the Commonwealth of Dominica. Today, it falls to me to address the Court on why the Commonwealth of Dominica submits that the Court's opinion on climate change is needed to authoritatively clarify, first, states' legal obligations with respect to climate and environment, and second, the legal consequences of those obligations where there has been a breach, in particular regard to small island developing states like the Commonwealth of Dominica. Due to our special circumstance and with particular regard to the future generations. Preliminarily, I wish to address the Court on 3 points. Firstly, it is without a doubt there is consensus among states appearing before the Court that the Court has the jurisdiction to deliver the requested opinion. And secondly, the question before the Court is a question of law, clarifying the law. Thirdly, the science. The Court is asked to affirm the science relating to climate change is clear, as it is the best available science, and it is widely accepted that there has been an unprecedented adverse change in the climate system from the end of the Industrial Revolution in 1850 to 2020. The IPCC reports, which are credible sources and credible reports of climate change, and were adopted by consensus by most states here today, clearly with high confidence, state, 1, the cause of climate change, despite other states suggesting otherwise to the Court, and 2, the impacts of climate change. Science confirms that the surface temperature of the ocean or sea is warmer than ever before, and warm sea waters lead to greater intensity in hurricanes. You would have seen on September 18, 2017, Hurricane Maria intensified into a Category 5 hurricane roughly 24 hours after being upgraded from a tropical storm. The potential intensity of Hurricane Maria was not realized until 2 hours before landfall on the Commonwealth of Dominica. 226% of the Commonwealth of Dominica's GDP was wiped out overnight. The Commonwealth of Dominica echoes the sentiments of other small island developing states that, despite historically contributing less to the current climate crisis, Dominica, the Commonwealth of Dominica, is on the front lines of those disproportionately affected. By the World Bank's assessment, there is a clear impact and visible correlation between the incidence of climate events and the Commonwealth of Dominica's economic growth. The World Bank states, I quote, climate change could disproportionately magnify disaster risk in Dominica due to rising temperatures and sea level and associated coastal erosion, flood and storm surge. The Commonwealth of Dominica does not intend to examine the entire body of international law or all the treaties referenced in the question. The treaty discussion was well ventilated by other state submissions, written and oral. I will, however, address the Court on 2 specific areas. Firstly, the obligation of prevention and principle of due diligence, and secondly, considerations of international human rights. I will thereafter address the Court on legal consequences, referring to 3 specific areas. 1, cessation, 2, compensation, and 3, non-repetition. The Court will agree that the obligation of prevention is a fundamental principle of international law. Under customary international law, a state cannot allow its territory to be used for acts contrary to the rights of another state. The Commonwealth of Dominica submits there is wide consensus in the written statements of states here that the principle of prevention is a general principle of international environmental law and applies to all forms of significant environmental harm from climate change. And as such, legal obligations are found in more than the United Nations Framework Convention on Climate Change, the UNFCCC, and the Paris Agreement. As the Court set out in the Paul Mills case, in the context of international environmental law, each state is required to use all means at its disposal in order to avoid activities in its territories or in any area under its jurisdiction from causing significant harm to another state. The obligation to prevent transboundary harm was very recently discussed by the Court in 2022 in the dispute over the status and use of the waters of the sea, Chile versus Bolivia. The Court said that states must use all means at their disposal to fulfill their obligations not to cause harm. The Court recognized in the legality of the threat of use of nuclear weapons, advisory opinion that there is a, quote, general obligation of states to ensure that activities within their jurisdiction and control respect the environment of other states or of areas beyond national control. The Court said, and I quote, the Court recognizes that the environment is under daily threat and that the use of nuclear weapons could constitute a catastrophe for the environment. The Court also recognizes that the environment is not an abstraction, but represents the living space, the quality of life, the very health of human beings, including generations unborn. The existence of the general obligation of states to ensure that activities within their jurisdiction and control respect the environment of other states or of areas beyond national control is now part of the corpus of international law relating to the environment, end quote. It is no hyperbole that greenhouse gas emissions have weaponized the sea into a catastrophic threat. It is the Commonwealth of Dominica's submission that climate change is a daily threat to the life, the very health of human beings, including generations unborn. The caution urged by some states regarding the Court's approach to this question is misplaced. Small island developing states are not asking the Court to act recklessly, but rather to provide a clear and authoritative interpretation of existing law. As there is no caution in relentless winds, torrential rains, and extreme weather that batter and ravage our islands, nor in the rising sea that threatens to engulf and swallow our islands whole. The Commonwealth of Dominica affirms and adopts Belize's oral submissions and written submissions on the prevention obligations, causation and assessment obligations to prevent transboundary harm, and the duty of due diligence, and asks the Court to affirm that treaties have not displaced the independent, customary international law obligation. I now turn to consider international human rights. International law recognizes that the obligation to refrain from large-scale violations of human rights are obligations which are erga omnes, recognized as peremptory norms of international law. It bears repeating that, I quote, every human being has an inherent right to life. A clean and healthy environment is intrinsic to this right to life, as is the right to enjoy that life with dignity and to be free from acts and omissions that would cause unnatural death. Climate change and the resulting adverse weather conditions is a direct threat to the life and enjoyment of life and the mental well-being of every citizen of the Commonwealth of Dominica. It is no small feat to rebuild your home and life after hurricanes and recover from the constant onslaught of adverse climate conditions and have to prepare again and again every year for this uncontrollable threat. The Commonwealth of Dominica supports the position of states that the right to life, the right to a healthy environment, and the right to self-determination are human rights that have been breached by the emission of greenhouse gases and climate change. Furthermore, the ICLOS advisory opinion spoke in very clear terms that greenhouse gases is pollution. I repeat, greenhouse gases is pollution. For the purposes of UNCLOS, the court is asked and invited to affirm the advisory opinion of ICLOS and set out in this requested opinion that a state's legal obligations require it to take all measures with a view to reducing and controlling pollution from greenhouse gases and to protect the marine environment. The court is asked to reject any lex specialis arguments, particularly those which seek to position the question before the court as solely under the ambit of the UNFCCC. The court in this advisory opinion is asked to similarly hold the view as the chamber in LC did, and I quote, find itself unable to accept that an important principle of international law should be held to have been tacitly dispensed with in the absence of words making clear an intention to do so, end quote. Higher meeting states are skirting any responsibility with nuanced, but it is submitted flawed arguments. We ask the court to set aside these arguments as flawed and restate that in the context of climate change, customary international law principles have not been replaced by and cannot be replaced by treaty provisions because there have been no clear words with intention to do so. Any arguments that suggest otherwise should also be rejected. It is a matter of fact that some states, such as Nauru, Kiribati, and Fiji, specifically declared that signing the UNFCCC was not a renunciation of any rights under customary international law. The Paris Agreement acknowledges that Article 8 is not meant to create legally binding obligations on liabilities. This, as one state said, and I quote, exemplifies why other sources or rules of international law are required to clarify the full extent of states' obligation in relation to climate change beyond the UNFCCC and Paris Agreement, end quote. As to legal consequences, the Commonwealth of Dominica believes the court is well placed to pronounce on liability and the accountability for environmental damage as it relates to climate change. Further, that the Articles on Responsibility for States' Internationally Wrongful Act, or the ILC Articles on State Responsibility, is a fundamental concept of international law and is fully applicable in the context of greenhouse gases and climate change. Although some states may argue that the ILC Articles on State Responsibility should not apply in the climate change context and feel there is great deal of merit in that argument, the Commonwealth of Dominica asks the court not to accept these arguments, despite how skillfully crafted and attractive they are, and pronounce that breaches of states' international obligations arose from, quote, a composite act, end quote, in terms of Article 15.1 of the ILC Articles on State Responsibility, and, quote, are a series of actions or omissions defined in aggregate as wrongful, end quote. The Commonwealth of Dominica submits that every intentionally wrongful act of a state is the international responsibility of that state. And where several states independently commit separate acts that contribute to harm, responsibility may be allocated based on equity and proportionality, or in accordance with the principles of joint and several liability, depending on the particular circumstance. The court is asked to bring accountability to the forefront of climate change and accountability to greenhouse gas emissions, and similarly pronounce now, as the court did in the Barcelona traction case, that all states have a legal interest in obligations owed to the international community as a whole, in view of the importance of the rights involved. With respect to legal consequences, the Commonwealth of Dominica states, firstly, a state's rights, human rights obligations, and due diligence obligations require them to reduce greenhouse gas emissions and provide guarantees of non-repetition. Secondly, the court is invited to pronounce that breaching states are liable to compensate the vulnerable states that have been harmed by their composite conduct. There is international authority for the proposition that reparations for environmental harm may vary depending on the obligations violated. And the nature of the injury in the cases of armed activities on the territory of the Congo, Democratic Republic of the Congo versus Uganda at paragraph 93 to 94. And the case, certain activities carried out by Nicaragua in the border area, Costa Rica v. Nicaragua, at paragraph 15, paragraph 44, referred very helpfully and canvassed in Vanuatu's written submissions and comments. The Commonwealth of Dominica, as other states have set out, state that the court can consider compensation may include, or the court's consideration of compensation may include, technical assistance that ensure states like Dominica, vulnerable governments, enhance resilience without jeopardizing fiscal stability or diverting funds from development goals, and that any assistance should not be seen as stated by Colombia in their written and oral submissions, I quote, a mere expression of goodwill by developed states, but an actual obligation stemming from the commission of various continued internationally wrongful acts against the environment, resulting from historic and current greenhouse gas emissions. 2, another consideration could be providing funds to small island developing states at concessionary rates. As to non-repetition, the court is asked to reaffirm that there should be a commitment by states to not repeat the harm. In conclusion, the Commonwealth of Dominica asked the court to, in a very frontal way, address the responsibility for emissions of greenhouse gases and climate change in the context of customary international law and rightly reaffirm the human rights responsibility and states' responsibility relating to climate change are erga omnes. On behalf of the citizens of the Commonwealth of Dominica and its future generations, our children and our children's children, we ask the court to use this opportunity in this advisory opinion to promote justice, accountability in climate change. We ask the court to choose to be on the right side of climate history. For this, our earthly home, for to not do this will be to deny the existence of a legal obligation to address climate change and the resulting responsibility for the conduct of states is to mock the lived reality of the people of the Commonwealth of Dominica, a small island developing state. I thank you.
The representatives of the Commonwealth of Dominica for their presentation. I now invite the Republic of Korea to make its oral statement before the court, and I call upon Mr. Wang Junqing to take the floor.
Mr. President, members of the court, it is an honor to appear before you today on behalf of the Republic of Korea. In our written statement, we presented several general observations on the 2 questions posed by the General Assembly. We emphasized that the purpose of the request for the court's advisory opinion would be fulfilled by the court clarifying the existing law rather than by seeking to lay down new rules in relation to complex matters of policy that are the subject of ongoing negotiation among states. Today, I will elaborate on certain issues related to the first question, question A. I'll be followed by Professor Lee Geun-kwan, who will address question B. I will begin by addressing the significance of an advisory opinion in the present context, as well as the relationship between the climate change treaty regime and other sources of international legal obligations that may be relevant. Next, I will discuss more specifically the relevance of the law of the sea and international human rights law. I will then highlight the need for a rigorous approach to the determination of any applicable rules of customary international law before asking you to call on Professor Lee to take the floor. Mr. President, there is no doubt that the climate crisis is the most pressing challenge faced by humanity at this time. The impressive number of states that are participating in these proceedings demonstrates the significance attached to this issue and to this case. Given that the world is suffering greatly from climate change, especially small island developing states that are particularly vulnerable to its adverse effects, there is a broad consensus that a coordinated response by the international community is urgently needed. In this regard, let me reiterate our view that the Court has jurisdiction to give the requested advisory opinion, and there is no compelling reason for it to decline to do so. Again, we also consider that the Court can make a very important contribution by clarifying the existing law relating to obligations in respect of climate change. It should do so without hindering ongoing negotiations on this subject, especially those taking place at the Conference of the Parties of the UNFCCC, which serves as the central forum for discussion and agreement on joint action. The centrality of the climate change treaty regime in delivering a coordinated global response appears to be common ground in this proceeding. In this vein, heads of state and government have recently committed through the Pact for the Future adopted by the General Assembly in September this year, quote, to accelerate meeting our obligations under United Nations Framework Convention on Climate Change and the Paris Agreement, end quote. The Republic of Korea has been an active participant in the international community's response to the climate crisis. In addition to the efforts already mentioned in our written statement, we hosted last year in Seoul the first Korea-Pacific Island Summit, after which the participating leaders declared that climate change remains the single greatest threat to the peoples of the Pacific, and that they will work together on the implementation of the Paris Agreement. We have also been contributing to projects such as the Rising Nations Initiative to safeguard the rights and heritage of the Pacific population from rising sea levels. In July this year, the Republic of Korea announced a contribution of $7 million to the Fund for Responding to Loss and Damage to help developing countries cope with the adverse effects of climate change. And at the recent COP29, Korea also announced a contribution of $20 million to the Partnership for ASEAN-ROK Methane Action for a large-scale project that aims to catalyze the reduction of methane emissions in the ASEAN region in response to climate change. Mr. President, turning now to the relationship between the climate change treaty regime and other sources of international legal obligation that may be relevant, it is widely recognized and indeed uncontested that the UNFCCC and the Paris Agreement are the primary sources of international law addressing climate change for the parties thereto. It is these treaties which most clearly lay down obligations for ensuring the protection of the climate system and the environment from the anthropogenic emission of greenhouse gases. As ITLOS observed in its recent advisory opinion, there is an extensive treaty regime addressing climate change and the UNFCCC and the Paris Agreement are primary treaties addressing climate change. Core obligations that are laid down in the Paris Agreement, including in Article 4 thereof, stem exclusively from this treaty and do not flow from other sources of international law. In this light, for those states that are parties to the climate change treaties, the essence of the answer to question A is grounded in the UNFCCC and the Paris Agreement. However, this does not mean that the climate change treaty regime is the only source of law applicable to combating climate change, and that international legal norms outside the climate change treaty regime are entirely irrelevant. This becomes clear when you think about a state which is not a party to the climate change treaties. Such a state would be bound by corresponding or other applicable rules of customary international law. In addition, other treaties to which the state is a party may be of relevance. For example, as long as the state is a party to the UN Convention on the Law of the Sea, UNCLOS, or to human rights treaties, it would be obliged, as the case may be, to exercise due diligence in protecting the marine environment from the negative impacts of climate change and to ensure the protection of the relevant human rights of individuals within its territory. Indeed, giving normative priority and centrality to the climate change treaties and regarding them as lex specialis does not mean evading or setting aside other international legal obligations. The ILC's study group on fragmentation of international law had recognized in the same vein that characterizing a treaty as lex specialis may not always lead to the setting aside of the general treaty. Mr. President, while the climate change treaty regime stipulates certain specific obligations that cannot be derived from other sources of international law, other sources of international law can undoubtedly complement that regime. UNCLOS, for its part, does not expressly refer to an obligation to protect the climate system from greenhouse gas emissions, but is clearly relevant to climate change, as was confirmed in the advisory opinion given by ITLOS last May. In that advisory proceeding, the Republic of Korea expressed its view that a general obligation of conduct to promote the protect the marine environment from climate change can be derived from Articles 192 and 194 of UNCLOS. We also stated in our written statement in that case, and in the present one, that the Convention provides a basic legal framework for addressing aspects of climate change through the obligations to protect and conserve the marine environment. Several points in the advisory opinion given by ITLOS, which we generally support, may have benefited from further explanation. This may be said, for instance, of the statement that the standard of due diligence is even more stringent with respect to transboundary pollution affecting the environment of other states than in relation to the more general obligation to prevent, reduce, and control marine pollution from anthropogenic greenhouse gas emissions. That said, the ITLOS advisory opinion contains a sound analysis of the relationship between UNCLOS and climate change based on the concept of obligations of conduct and the due diligence standard. Therefore, there seems to be no reason for this Court to depart from the approach adopted by ITLOS, also bearing in mind that the Tribunal is entrusted with providing authoritative interpretations of UNCLOS. Like UNCLOS, international human rights law does not expressly refer to climate change. However, it may be said that human rights treaties in general require parties to act diligently in relation to climate change so as to take appropriate measures to prevent to the greatest extent possible adverse impacts on the enjoyment of human rights, including the right to life and the right to health. Moreover, states should respect, promote, and consider their respective human rights obligations when taking action to address climate change. At the same time, it needs to be kept in mind that international human rights law was not designed to address climate change. Looking at the issue of climate change through the prism of human rights is neither straightforward nor necessarily effective. It is also important to note that a state's obligations under human rights treaties only extend to individuals within its territory or under its jurisdiction. Mr. President, some obligations in respect of climate change may also be found in customary international law. We are aware that states have different views on whether, and if so how, rules of customary international law also apply to climate change. Our own view, on which we elaborated in our written statement, is that the obligations under customary international law, especially the principle of prevention of significant harm to the environment and the duty of cooperation, are applicable in the context of climate change as obligations to be undertaken with due diligence and can complement the relevant treaty obligations. We also consider that the determination of rules of customary international law must be rigorous in the present context as in others. Since the Court must not anticipate the law before the legislator has laid it down, it must be careful not to identify new obligations under customary international law that are not sufficiently grounded in a general practice accepted as law. As the Court explained in a previous advisory opinion, it, quote, states the existing law and does not legislate. This is so even if, in stating and applying the law, the Court necessarily has to specify its scope and sometimes note its general trend. Mr. President, members of the Court, I thank you for your attention and now respectfully ask that you invite Professor Lee to take the floor.
I thank Mr. Wang, and I now give the floor to Professor Lee. You have the floor, Professor.
Mr. President, Madam Vice President,